Hi, in this video I want to talk to you about sexual offences, of course, that we detail within chapter 8 of the textbook, and particularly thinking about if you're answering a problem type question, how you can identify which one of those offences you're going to apply to your problem facts. Now, this is particularly challenging in relation to sexual offences simply because the Sexual Offences Act 2003 introduces such a variety and such an extreme amount of offences that many of which overlap considerably with one another. So one of your main challenges is not simply to apply the offences, but actually the first step of identifying which offence you are going to discuss in detail can itself be quite challenging. Now, in recognition of that, sometimes your lecturers will be nice and they will tell you at the bottom of a problem question, discuss liability for, and then name a particular offence. So they might discuss David's potential liability for sexual assault, or describe or discuss Paul's potential liability for rape, or whatever it might be. Now, in those scenarios, of course, you have your direction, you have your offence already picked out for you, and all of your discussion within the problem question should be about potential liability for that particular offence. However, there will be problem questions, of course, which simply say discuss potential liability, and in these scenarios you will need to identify a particular offence. Now, to try and help you with that within the textbook, we have a chart where we basically detail the types of offences and trying to give you a kind of a route through to identifying which offences are probably more likely to be applied or more appropriate to be applied. And we do that in a couple of ways. The first way, and I think this is often the useful starting point, is to look at the age of the victim. So within the flowchart that we give you, or within the chart that we give you within the textbook, that's on the left-hand side where we have 18 plus at the top, then 16, 17-year-olds, 13 to 15, and 0 to 12. Those are the ages of the victim. Now, the reason that's important is particularly in relation to the very young victims, we have offences which recognise that if the defendant is committing the actus reus of a sexual crime in relation to that very young victim, then issues that are often quite complex, such as consent, aren't really at issue. They're not relevant to those offences. The very fact that our defendant has chosen to do that to a very young person, we don't have to engage with whether that young person willingly accepted that contact or not. Rather, it's simply enough to say, if the defendant did it and if the victim was that young, then there will be liability. So if you have a particularly young victim, as we state across there, we've got sections, for example, 1 to 4 wouldn't be necessary in all cases. They will still apply, but for sections 1 to 4 you need to demonstrate a lack of consent, which is often very difficult. Rather, the more appropriate offences would be sections 5 to 8, for example, where simply a very young victim in itself satisfies that requirement, and there's no need to go on to look at issues of consent. So first of all, as I say, you can place the types of offences that will be most appropriate depending on the age of the victim. From there, you can then also start to think about other potential vulnerabilities. So for example, we have specific offences that deal with sexual contact where the defendant is in a position of trust. So having identified the age of your victim, you can then look for those other potential vulnerabilities. Or if, for example, the defendant is a family member of the victim, or for example, if the victim has a particular mental disorder that impedes their ability to make a choice. Now, in each of those scenarios, you basically can cross-section along and identify which are the most likely offences you should be applying in practice. Now, this kind of chart should be useful to you, obviously particularly in courseworks where you have time to think over a longer period of time about which offences you think are more appropriate. But equally, if you get used to using it when you're doing your practice essays, it should become more of a second nature to you then in the exam as well, to identify what are the crucial points, what's the age of our victim, are there any other associated vulnerabilities, and in that sense help you to identify what is the most relevant offence that you should be looking at. Now, generally, when we think about that choice of offence, there are 3 other factors that we need to consider. The first one is, generally speaking, we would be applying the most serious potential offence. That's a general rule across the criminal law, that a prosecution would look to what is the most serious description of our defendant's behaviour, and that will usually be the more appropriate offence. But secondly, you've got to look at the more appropriate label. So for example, if you have sexual assault where the defendant's in a position of trust, even though it perhaps might be just as easy to charge a simple sexual assault under Section 3, you might say to your reader within your problem answer that either offence could be charged, but actually it looks like a more appropriate label to charge the offence based on the abuse of a position of trust. And finally, and this is also important, of course, for sexual offences in particular, you want to think about what's the most likely to actually be satisfied. So if you were the prosecuting authority, which offence do you think will be easiest for you to prosecute, for you to demonstrate the elements of? And this is why, in particular, although sections 1 to 4 are the most serious, generally perceived as the most serious offences, because they require a demonstration of a lack of consent, they're often very difficult to prosecute, which is why the variety of other offences where you don't have to demonstrate that lack of consent are often more appealing. So again, within your problem question answer, you may well say this potentially could be, for example, even a rape under Section 1. However, because of the victim's age or because of other aspects of vulnerability, it's likely that a prosecution would actually charge this alternative offence, although, as I say, perhaps the full offence of rape could be charged, an alternative might be more appropriate because it doesn't require us to engage with questions of non-consent. Okay, so that might sound quite convoluted, and there are a number sometimes of different factors at play when you're choosing your offence, but hopefully, as I say, the chart will help you. But also consider those 3 factors. In terms of seriousness, generally the more serious is the one that you would apply. In terms of appropriate labelling, what is the best description of the defendant's behaviour? And finally, in terms of what is it going to be easiest for the prosecution to demonstrate. As long as you take account of those and you tell your reader why you're choosing the offence that you're choosing, that can only be the right way forward. Thank you.